Far too often, I've had non-custodial parents try to tell me that they can't do anything because the custodial parent has sole custody. This is frustrating for me because very often it's not true. There may be some rare instances where it is true, but for the most part it is not true. My name is Bradley Supernaw. I'm an attorney in Nebraska, and this video is going to discuss what a non-custodial parent can do to try to enforce their rights. In particular, I'm going to discuss contempt as always, this video is not intended to be legal advice. Every case is going to be a little bit different, so the facts of your case may cause outcomes to be different than what is discussed in this video. Also, if you're not in Nebraska, the procedures may be different in your state, so it is important to contact a lawyer in your state to discuss if the custodial parent is not allowing you, for example, to see your children. If a custodial parent is interfering with your parental relationship with your children, there are a couple of ways that it can be addressed. First and foremost, you need to make sure that you have a parenting plan in place, one that is approved by and ordered by the court. The parenting plan will spell out your rights as a non-custodial parent. If you do not have a parenting plan, then you can file it with the court to establish custody and to establish parenting time and a parenting plan. If your parenting plan has been approved by a court, it has the same effect as in an order. If you do have a parenting plan and it has been approved by the court and the custodial parent is not obeying the parenting plan, then that parent may be in contempt of court. In the family law context, when we talk about contempt of court, we're talking about civil contempt and not criminal contempt. Civil contempt occurs when one party willfully and contumaciously disobeys a court order. Willfully means they do it intentionally. It doesn't mean that they have to intend to disobey the order. It just means that they have to intend to do the act, which is contrary to the order. Contumaciously is one of those words that you will probably only hear from a lawyer. Contumaciously means that someone is stubbornly disobeying the court order. It means that there's a kind of a pattern of conduct, really. In the family law context, the most common example of contempt arises when one parent does not allow the other parent to see the children, or if that parent does not otherwise follow the parenting plan. For example, it might be not following the holiday schedule or the summertime schedule. Contempt in a family law situation can also arise from disobedience of other court orders, such as a temporary custody order, or if you were part of a divorce, the divorce decree itself. So, for example, if in the decree one spouse is awarded the marital home subject to the mortgage with an order to refinance that mortgage within a certain amount of time so that the other spouse is no longer on the mortgage, and the spouse that was awarded the marital home does not do so, that spouse may be in contempt. A contempt proceeding is started with a motion for an order to show cause. The motion will spell out the facts and the reason why the moving party believes the other party is in contempt. The judge will issue what's called an order to show cause. This is just an order for the non-moving party to appear on a certain date at a certain time to show cause why they should not be held in contempt. In Nebraska, the order to show cause and the motion that it is based on will have to be served on the other party in the same way that the complaint was served. Usually that means that the sheriff of the county where they live will serve them with the order to show cause and the motion. At the hearing, the court will hear testimony and receive evidence both of why the person should be held in contempt and why they should not be held in contempt. The burden starts with the party who filed the motion to show that the non-moving party or the other party is in contempt. If the moving party meets that burden, then the other party will have the opportunity to present testimony and evidence as to why they are not in contempt or why they should not be held in contempt. The evidentiary standard in a contempt proceeding is called clear and convincing. There are a couple of evidentiary standards that you may have heard before. One is by preponderance. That basically means more likely than not, 50% plus 1 probability, for example, that something did occur. This is the most common standard in civil proceedings. Another one that you may have heard is beyond a reasonable doubt. That's used in criminal proceedings. It's a constitutional standard. It is a very high standard. The clear and convincing standard for a contempt proceeding is somewhere in between these two. It's more than a preponderance, but it's not as high a standard as beyond a reasonable doubt. Clear and convincing basically means that it is substantially more likely to be true than not true. So take, for example, your ex-husband or your ex-wife was granted primary custody of your children in the decree, and you were granted, for example, every other weekend, maybe extended time during the summer, and certain holidays. If there comes a point where the custodial parent, your ex-spouse, stops allowing the children to come over to your home, then that spouse may be in contempt. And you're talking about a pattern of, not just once, but it may be over a period of a month, 2 months, 3 months. One excuse that custodial parents will often use is that the children don't want to go over to the other parent's house, so how can they make them, or they don't want to make them, or something along those lines. For that parent, that is not a legitimate excuse. The custodial parent has a duty to, as much as they can, make sure that they are not doing anything that would cause the children not to go over to the other parent's house. And if you are the custodial parent in a situation like this, you should know that the children are not part of the decree. The children are not subject to the court order, but you are. And if there is going to be any contempt or any sanction by the court, it is not going to be against the children, it is going to be against you. So it is in your best interest to do what you can, as I said, to make sure that you're not doing anything that would cause the children not to want to go to the other parent's home. If one parent is found to be in contempt, because this is civil contempt, they are allowed the opportunity to cure the contempt. Basically, that means that they are going to be sentenced to some jail time. Usually, in my experience, it's between 7 and 14 days, and it's going to be set to begin sometime in the future, month, 2 months, 3 months in the future. And before that time, they can do what the court tells them to do to cure the contempt or to fix what they had done wrong. So, for example, if the custodial parent is not allowing the children to go to the non-custodial parent's house on their weekends, the court may say the non-custodial parent missed, for example, 3 weekends, then they get 3 weekends to make up. If those 3 weekends are made up before the jail time starts, then the custodial parent will avoid jail time. In the example with the marital home, where the spouse who was awarded the marital home is ordered to refinance but is unable to or has not taken any steps to do so, if they are found to be in contempt, in that type of situation, the court might give them a certain amount of time to either refinance or put the home on the market. So all this video is just to say that just because the other parent might have full custody or sole custody, that does not mean that the non-custodial parent is without rights. The non-custodial parent is still a parent and still has rights. If you are in a situation where you feel that the other party is in contempt, the Nebraska Supreme Court website has some very good resources. If you are in a situation where you feel like the other parent is in contempt, the Nebraska Court's website has some very good resources. If you go to nebraska.supremecourt.gov, on the upper right, I'm not sure if this in the video is the upper right, but to me it's the upper right. In the upper right, there will be a link to self-help. And when you pull up the self-help page, on the left-hand side, there's a list of different topics. One of those topics is going to be families and children. And under the families and children, there will be another topic for enforcing visitation orders. And under that topic, it will give you some description about what contempt is, how to go about it, what needs to be done. It'll give you some forms that you can use and tell you about the hearing, what needs to be done at the hearing. And of course, if you don't feel comfortable doing it, you may want to speak to an attorney. So that's it for this video. Again, it's very frustrating to me to have a non-custodial parent come to me and say, well, there's nothing I can do because the other parent has sole custody or has full custody, or there's no court order parenting plan in place. With a few exceptions, even if you're not the custodial parent, you are still a parent and you do still have rights. And the courts can help you protect your rights if the other parent is not complying with the court order, or if there is no court order, if the other parent is not letting you see your children. Either way, there are things you can do to protect your rights. Thank you for watching, and I hope you found this video informative.